Real estate disputes in Seattle rarely begin as courtroom battles. They typically start as misunderstandings, informal agreements, or assumptions that go untested until money, property rights, or reputations are on the line. By the time parties consult litigation counsel, positions have hardened and the cost of resolution has multiplied. In Washington state, where property values have risen dramatically and regulatory frameworks are detailed and evolving, early legal strategy is not optional. It is often the dividing line between a negotiated solution and years of expensive litigation. Seattle's real estate market is governed not only by contract principles but also by state statutes such as the Washington Residential Landlord-Tenant Act, local housing regulations, zoning codes, and disclosure requirements that impose affirmative duties on sellers and landlords. A misstep in any of these areas can trigger claims that escalate quickly. The pattern is familiar to attorneys who handle complex property and business disputes. Seattle-based attorney David Ruzumna, who has decades of experience handling real estate and commercial litigation matters, has seen how avoidable issues transform into entrenched legal battles when parties delay seeking guidance. His assessment is direct. Most disputes do not turn on obscure legal doctrines. They turn on documentation, expectations, and early strategic decisions. Few areas generate more disputes in Seattle than landlord-tenant relationships. Washington's Residential Landlord-Tenant Act imposes specific procedural and substantive obligations on both sides. Seattle adds additional local requirements concerning notice periods, just cause eviction standards, and tenant protections. Conflicts often begin with late rent, maintenance complaints, or disagreements about lease terms. What escalates the situation is procedural error. Improper notice, failure to follow statutory timelines, or miscommunication regarding payment arrangements can undermine a landlord's legal position before a case ever reaches court. For tenants, withholding rent without understanding statutory repair and deduct rules or retaliation protections can create exposure. For landlords, informal agreements not memorialized in writing frequently lead to allegations of unlawful eviction or discrimination. Early intervention matters. Clear written communication, documented repair requests, and strict adherence to statutory notice requirements create defensible records. Once an unlawful detainer action is filed, the margin for correction narrows considerably. Attorneys who focus on this space often emphasize that compliance with Washington law is not intuitive. Local courts expect precision. Missteps can result in dismissal, attorney fee exposure, or statutory penalties. Real estate transactions in Seattle are contract-driven. Purchase and sale agreements, commercial leases, development agreements, and partnership operating agreements allocate risk in detailed ways. Disputes typically arise when market conditions shift or contingencies are triggered. Earnest money disagreements, inspection contingencies, financing failures, and representations about property conditions frequently lead to claims of breach. Commercial leases introduce additional complexity, including common area maintenance charges, assignment clauses, and personal guarantees. Washington courts interpret contracts based on objective manifestations of intent. Informal side conversations rarely override written language. Parties who rely on verbal assurances often find that the written agreement governs. David Ruzumna has built a substantial portion of his practice around analyzing claims at their elemental level. He emphasizes identifying the elements of each claim early and matching them to available evidence. In real estate disputes, that means examining not only the contract language but also correspondence, timelines, and performance history. A strategic early review can sometimes reframe a dispute. Parties may discover that a perceived breach is instead a misunderstanding about conditions precedent or notice requirements. Alternatively, a thorough early assessment may reveal that a quick settlement is more economical than protracted litigation. Seattle's growth has intensified zoning and land use disputes. Property owners seeking to develop, subdivide, or repurpose land often encounter regulatory hurdles at the city or county level. Appeals of permit decisions, challenges to land use determinations, and neighborhood opposition can stall projects for months or years. Washington's Growth Management Act and local zoning codes impose layered requirements. Developers and property owners must navigate environmental review processes, public notice procedures, and administrative appeals. A failure to follow procedural rules can forfeit rights to challenge adverse decisions. Zoning disputes escalate when owners invest significant capital before securing clear approvals. If a permit is denied or conditioned in unexpected ways, sunk costs increase pressure and conflict. Early legal counsel can identify procedural deadlines, preserve appeal rights, and evaluate whether negotiation with planning authorities may be more productive than litigation. In many cases, a strategic approach at the administrative stage prevents a full-scale court battle. Boundary disputes remain a persistent source of litigation in Washington. Survey discrepancies, fence placements, shared driveways, and implied easements often lie dormant for years until a sale or redevelopment brings them to light. Washington law recognizes doctrines such as adverse possession and prescriptive easements, which can alter ownership rights based on long-term use. Property owners who assume that a fence line reflects a legal boundary sometimes discover otherwise when a formal survey is conducted. These disputes become personal quickly. Neighbors may have coexisted amicably for years before a title issue disrupts expectations. Once allegations of encroachment or trespass are asserted, positions harden. Early steps are critical. Commissioning updated surveys, reviewing recorded plats, and documenting historical use can clarify leverage before accusations escalate. In many cases, mediated boundary agreements resolve matters more efficiently than trial. Seattle's entrepreneurial environment has produced numerous real estate partnerships and joint ventures. These relationships often begin with optimism and informal understandings among friends or colleagues. When projects underperform or market conditions change, disputes surface. Operating agreements and shareholder agreements govern decision-making authority, capital contributions, and exit rights. Problems arise when agreements are silent on key contingencies or when partners diverge in risk tolerance. Claims may include breach of fiduciary duty, mismanagement, or disputes over profit distributions. Because these ventures often involve closely held entities, conflicts can disrupt not only property ownership but also ongoing business operations. Attorneys with experience in both business and real estate litigation are positioned to analyze these disputes holistically. David Ruzumna's background handling complex business-related conflicts informs his approach to partnership breakdowns, where legal strategy must account for financial realities and interpersonal dynamics. Early candid assessment of rights and obligations can prevent destructive litigation. Sometimes that means negotiating buyouts before value erodes further. Other times it means preserving evidence and preparing for formal proceedings when resolution proves impossible. Washington sellers are subject to statutory disclosure obligations, particularly in residential transactions. Seller disclosure forms require affirmative statements about known defects, environmental issues, and structural problems. Failure to disclose claims often arise after buyers discover conditions they believe were concealed. Litigation in this area turns on knowledge and materiality. Did the seller know of the defect? Was the defect material to the transaction? Did the buyer rely on the representation? These cases are document-intensive. Inspection reports, repair invoices, email communications, and contractor statements become central evidence. Buyers who skip inspections to remain competitive in a tight market may face challenges proving reliance. Preventative measures are straightforward but frequently ignored. Sellers should answer disclosure forms carefully and consult counsel when uncertain. Buyers should document inspections and communications. Once a complaint is filed, reconstructing intent becomes far more difficult. Across these categories, the common denominator is delay. Property owners often consult attorneys only after receiving a demand letter or being served with a complaint. By then, strategic options may be limited. Early legal strategy does not mean immediate litigation. It means informed decision-making at the outset of a conflict. That includes evaluating exposure, identifying documentation gaps, and understanding statutory timelines. Clear documentation is foundational. Written confirmation of agreements, organized records of communications, and contemporaneous notes can shape outcomes months or years later. Courts in Washington frequently decide motions based on written submissions. Precision in drafting and record-keeping matters. Seattle-based attorney David Ruzumna frequently underscores that litigation is as much about communication as it is about doctrine. Clients who understand costs, timelines, and risk profiles are better positioned to make rational decisions. That clarity often reduces escalation. Property owners in Seattle can reduce litigation risk by taking several preventative measures. They should review leases and contracts periodically rather than assuming template language remains sufficient. They should respond to disputes promptly in writing and avoid informal side agreements that contradict formal documents. For development or zoning matters, they should verify compliance before investing heavily in construction or improvements. For partnerships, they should revisit operating agreements when circumstances change rather than relying on past goodwill. Most importantly, they should seek counsel early. A brief consultation at the first sign of conflict can clarify rights and obligations and prevent costly procedural mistakes. The cost of early advice is typically modest compared to the expense of prolonged litigation. Real estate disputes in Seattle escalate when assumptions replace documentation and when emotion overtakes strategy. Washington law provides structured rules for resolving these conflicts, but those rules reward preparation and foresight.